Good morning. We welcome everybody to this important hearing. We're here to discuss a cutting-edge question: what inventions should be eligible for U.S. patent protection? But first, as you can see on my right, the absence of a very important member of this committee for decades. I think it's important that we take a few minutes to remember and honor our friend and colleague, Senator Lindsey Graham. He passed away over the weekend, as we all know. He leaves behind a distinguished career as a U.S. Senator and former chairman and ranking member of this committee. Lindsey was a resounding voice in this Judiciary Committee, especially through the high-profile and successful confirmations of Justice Brett Kavanaugh and Justice Amy Barrett. He saw many conservative judges appointed to all levels of the federal court. Notably, he did this and more through the COVID pandemic. Public service was Lindsey's calling. He approached it with enthusiasm and energy and tireless dedication. His leadership to this committee in the Senate and for this country will be missed. So I just want to take a moment of silence to remember Senator Lindsey Graham. Thank you very much. Our nation's founders understood the importance of patent protection to the economy and growth of our newborn nation. They guaranteed this protection in our Constitution, and then at the earliest time in 1790, the first patent law was passed. The task before us today isn't an easy one. Patent eligibility is a multi-layered legal issue with detailed tests and case-by-case rules created by the Supreme Court. This law must be culled and gleaned from many pages of the court's nuanced opinions. Next, we tie in science. All scientists, from genes to machines to artificial intelligence. Then we mix in insatiable human curiosity and boundless creativity. We begin to understand why this area of the law is so challenging and so relevant this very day. It is rules trying to keep up with scientific development and human imagination. There's much debate about how to deal with this complex patent issue. Senator Tillis has done excellent and diligent work, including holding multiple hearings in the Intellectual Property Subcommittee, and I believe this is the first hearing we're holding on legislation at the full committee level. We may or may not agree on this bill entitled Patent Eligibility Restoration Act. I don't yet know. Most of us are still studying and trying to understand the bill and the effects it'll have in order to determine what's the best path forward. That's why we're here today, to study and understand this important issue that has had tremendous impact on the well-being of humanity and the success of our economy. We have 4 experts joining us today. Thank you for being here, and others who are submitting written testimony for the record to help us understand this with insights and experience. The stakes couldn't be higher. Our country's leads the world in cutting-edge inventions and technology. This momentum fuels our economy and advances our society. It cures diseases and helps us grow enough food to feed people throughout the world. We have a responsibility to Americans to hold this lead and to the world to fulfill our potentials. The question we ask today is how we do maintain this momentum, and while also making sure that all Americans can benefit from these advances. Learning how to strike this balance is why we're holding the hearing today. We'll have a fascinating discussion. Senator Durbin.
Thanks, Mr. Chairman. I know this is a meeting of the Senate Judiciary Committee, but something's missing. Lindsey Graham's missing. After all these years of working together with him, his absence is felt personally by so many of us. For 4 years, I chaired this committee. He sat next to me. We were adversaries on many issues and many nominees. You would never have known it if you'd seen us outside this chamber, because we were trusted friends of one another. His word was good. When he told me he'd do something, he did it. And I tried to keep that same feeling of trust with dealing with him. He ended up voting for 75% of the Biden judicial nominees, 75%. Wasn't easy, but he said from the beginning, I think Republicans have to vote for Democrats and Democrats have to vote for Republicans. That's the way it's always been. I've tried to live up to that standard ever since. He was part of something called the Gang of Eight, which is really unique in the history of the Senate. There were literally 4 Democratic senators, myself included, 4 Republican senators, including John McCain and Lindsey, who sat down to rewrite the immigration laws of America, and that's long overdue. Well, we spent months at it, every night after the session, sitting down and going through another section. We finally put it together on a bipartisan basis. Lindsey was a critical element of it, a critical part of that, as were many of the members of my colleagues. And we put it to the floor. Business supported it, labor supported it, the groups across the board supported it. It was thoughtful, it was balanced, it was a remarkable achievement on a bipartisan basis. It passed in the Senate with an overwhelming vote, but unfortunately was killed in the House of Representatives. Lindsey was part of that Gang of Eight. Lindsey was part of every gang. He couldn't be kept away. And he was invited in because he was always trying to find that bipartisan position that resulted in a new law, a new idea, a new solution. It was very important to him. Over 20 years ago, I introduced in this committee a bill called the DREAM Act. The DREAM Act said if you came to this country, if your mother and father brought you here as a kid, you ought to have a chance to work your way to legal status and citizenship in this country. I introduced it over 20 years ago. It's passed on the Senate floor once in a while, on the House floor once in a while, never in both chambers. Each year, I would introduce the bill. I would look for a Republican co-sponsor. In the beginning, it was a lot easier. Then it became harder and harder. Eventually, the one person I could count on to be my bipartisan co-sponsor was Lindsey Graham. And he did it at political peril. That wasn't a very popular position among some very conservative Republicans. But he did it for me, he did it for those kids, and I'll never forget that he was there when we needed him. Last week, we were in Turkey at the NATO summit. Chris Coons and I and several members came together. We arrived to find, of course, Lindsey Graham, who got there before us, was working every crowd in every room. You'd think he was running for office. He had some ideas on how to end the war in Ukraine, and he wanted to share them with everybody there. Through the course of the week, we met with President Zelensky and many other leaders on a bipartisan basis. Each one of them greeted Lindsey by first name. Lindsey, it's great to see you. It just shows you his reach of influence and his involvement in the key issues, including war and peace of his day. I'm sorry to say that Wednesday was the last time I saw him. I think the same for Senator Coons last Wednesday. And then the terrible news came through on Sunday morning. I'm going to miss this man. He was an important part of the Senate, an important part of American government. He reached way beyond any definition of the job of senator. He was really a person you could trust on a personal basis. You could confide in it as he confided in you. I'm happy that his sister is going to take his place for the remainder of this year. He loved her. And when his parents passed away, he became legal guardian of his 13-year-old sister. It meant so much to him. I know he considered this only right as she being chosen to fill the vacancy. Loretta and I send our condolences to her and Lindsay's family and the legion of friends in South Carolina and literally around the world who worked with this great man. I'm going to miss him. Thank you, Mr. Chairman.
Thank you. Senator Tillis for an opening statement.
Thank you, Mr. Chairman. And I want to echo everything that's been said about Lindsay. He was a great man. Mr. Chairman, you may not realize this, but in some respects, Lindsey Graham's sort of responsible for this hearing today because it was in 2019, one of your former staffers, Ted Lehman, who became my chief, suggested that we reestablish the Intellectual Property Subcommittee, and Senator Graham authorized that. And the work of the subcommittee is now coming before the full committee for the first time. And Mr. Chair, I also have to say that I know that you may have some questions and concerns. You're still examining this legislation. I think it's a real testament to your leadership to be willing to elevate something to the full committee that you yourself are still trying to work through some of the issues, and I appreciate your leadership. It's our patent system, as Senator Grassley commented, is a part of our founding. I mean, we're the first nation to enshrine in our Constitution this concept of intellectual property, and I actually believe it's one of the reasons why we have become the innovator that we are. We started out thinking that thinking was important, and then being able to take that thought and put it into something that the person who invested their time and treasure could recover is it's what innovation is all about. It was such a brilliant idea. And it's not lost on me that some of the founding fathers were inventors themselves, and I don't know if it was a combination of vision or maybe some self-interest there, but either way, we got it right, like so many things in our Constitution. But the problem that we have with patent eligibility today is that we are on the brink of losing our innovation advantage if we don't figure out that the world has changed since the founding of the Constitution, and that things that we could not possibly have conceived of need to be considered potentially for a patent. And PARA is not guaranteeing that you're going to get a patent. It's simply saying the world has changed. The jurisprudence is all over the place. 12 judges have lamented the fact that they even have to deal with it when rendering a decision. And other jurisdictions are looking at expanding and have expanded eligibility. Why would the United States fall behind? I am not requesting legislation that guarantees anything can get a patent. At the end of the day, what PARA is trying to do is simply open the aperture to what may be patentable. And so today, we get to take, what I was telling the witnesses beforehand, the debate club up to another level. In my committee, some of y'all may have figured out I'm not overly formal. And I think we're at our best when we're doing work groups and we're having an exchange between the thought leaders directly. And so at the end of this hearing, the chair has allowed me to chair it, and I believe the chair is going to be leaving. You four should be taking notes, or your staff, because at the end of this hearing, when everybody else is probably worn out, I will stay here and we will drill down a bit on topics where that interchange is so critical. Because I believe, regardless of what side of the issue you are on right now, there is a path forward. And we can help those who are concerned with changing the status quo, but at the same time have a remarkable impact on really stimulating and fostering creativity going forward with a very different way of looking at eligibility. And I look forward to this committee, the committee hearing, and to your feedback. And Mr. Chair, again, I appreciate you holding the hearing. Thank you all.
I want to introduce our distinguished panel. I apologize. I was told you didn't want to speak. Please proceed.
Have you met a senator who doesn't want to speak? Mr. Chairman, thank you for your graciousness, and to you and Ranking Member Durbin for your long and deep friendships with Senator Graham. I had the blessing of having dinner with him last Wednesday night in Ankara with some of our staff. He talked about how excited he was for this coming Congress and for the way we might continue to do good things together legislatively on this committee and on others. My chief counsel just reminded me he was my lead co-sponsor of a bill signed into law by President Trump earlier this year, not widely remarked, but that extended the terms of bankruptcy judges in my state, his state, and many others. We were at times fierce partisan adversaries, but we also at times passed some really significant legislation, whether it was in immigration or innovation, whether it was advancing our national interests or our core values. Lindsey fiercely loved this country, and I am excited that his sister, whom he dearly loved, will be filling his seat for the remainder of this Congress, and grateful that I had the blessing of knowing this remarkable man who described himself as simply a country lawyer, but so often with his brevity and his incisiveness and his incredible humor, got to the core of an issue and drove it forward. And then also, Senator Tillis, thank you so much for your incredible partnership on this bill and on this topic. It has confounded many efforts at clearing the underbrush and clarifying the thicket. As you said, about 15 years ago, the Supreme Court started weighing into an area, Section 101 patentability jurisprudence, that was previously relatively clear. There have been huge changes in technology. Every member of the Federal Circuit at some point has reached out and asked us for guidance. Solicitors General have repeatedly requested that the Supreme Court revisit patent eligibility, but they have refused, denying nearly 100 cert petitions. And this isn't an academic exercise, as Senator Tillis just laid out. Developments in artificial intelligence, in blockchain, in medical diagnostics, in 5G are patentable in China and in Europe and not patentable here. And I view this as critical for us to address in order to restore American leadership and innovation and to advance our national security. If the court won't clean up this mess, Congress needs to act, and that's why Senator Tillis and I have been advocating for PARA over many Congresses. We at one point had 50 witnesses over 3 hearings on the subcommittee. Senator Tillis has been tireless and determined. I'm grateful this bill has the endorsement, the support of Senators Hirono and Blackburn, and the support of many other members of this committee. And Mr. Chairman, thank you for elevating this important topic to a full committee hearing. And I so look forward to this hearing today, to these 4 very talented witnesses, and just wanted to close by thanking Senator Tillis for his tireless engagement on this important issue. Thank you, Mr. Chairman.
Thank you, Senator Coons. I have the privilege of introducing these witnesses. Mr. Andrei Iancu. He's a co-chair of the Council of Innovation Promotion, a partner at the law firm Sullivan and Cromwell. Between 18 and 21, he served as director of the U.S. Patent and Trademark Office. Mr. Iancu earned his J.D., his M.S. in Mechanical Engineering, and a B.S. in Aerospace Engineering from UCLA. Mr. John Lee is Senior Director and Head of Intellectual Property Policy at the Computer and Communications Industry Association. He previously served as Chief Counsel for Intellectual Property on the House Judiciary Committee. Before that, he worked as lead administrative patent judge on the Patent Trial and Appeal Board at the U.S. Patent and Trademark Office. Mr. Lee received his law degree, BAS in Bioengineering and BA in Biology and Neuroscience from University of Pennsylvania. Dr. Debra Leonard fills, no, I'm sorry. I skipped one here. Sue Peschin serves as President CEO of the Alliance for Aging Research. She also serves on many boards, including the Association of Black Cardiologists, National Health Council, Voices of Alzheimer's, and others. Ms. Peschin received her master's degree in health policy, Johns Hopkins Bloomberg School of Public Health, and her bachelor's degree in sociology, Brandeis University. Dr. Debra Leonard fills out the panel. She currently professor of pathology and laboratory medicine Emerita at the Robert Larner MD's College of Medicine. That's at the University of Vermont. She serves as chair of the Department of Pathology and Laboratory Medicine until last year. Dr. Leonard earned her MD degree and her Ph.D. in biochemistry from New York University and her bachelor's degree in biology from Smith's College. Now, before you testify, we have a practice here of swearing people, so would you please stand? Do you swear or affirm that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth? So help you God. You've all responded in the positive, and so we'll start out with Mr. Iancu. Please proceed.
Thank you, and Chairman Grassley, Ranking Member Durbin, and members of the committee, thank you for the opportunity to testify today. Before I begin, I want to say that I am heartbroken about Senator Graham's passing. I was very much looking forward to seeing him on the dais today. He chaired this committee when I was PTO director, and I have only fond memories of our meetings. He was gracious, smart, witty, and he loved this country. He was a statesman in the best sense of the word. He fought hard for his beliefs, and he reached across the aisle when it served America's interests. May others follow his lead, and may his memory be a blessing. My message for this hearing is simple. Congress has not meaningfully updated the basic statutory categories defining what kinds of innovations and technology may be patented since 1793. Technology has changed a bit since then. Indeed, it has changed beyond recognition. The statute has not. What belongs in the patent system is a major policy question. The Constitution assigns that question to Congress. I urge Congress to answer it. And because Congress has not done so, courts have filled the void. And over the past 15 years, courts have expanded judicial exceptions that Congress never wrote and that lower court judges say they cannot administer consistently or fairly. The consequences are real. The result is uncertainty in the technologies that will define the century: computing, medical diagnostics, biotechnology, artificial intelligence, and so much more. For example, courts have rejected tests that diagnose serious diseases as laws of nature. They have rejected improved digital camera technology as an abstract idea. And they have treated the collection, analysis, and presentation of information as categorically suspect and likely not in the patent system. The resulting uncertainty discourages the resource-intensive research America needs to confront its greatest challenges, from detecting and treating thousands of diseases that remain without effective therapies to equipping our military with the most advanced computer-assisted technologies. Meanwhile, Europe, China, Japan, and South Korea, the biggest other IP jurisdictions, protect inventions that American courts turn away. That is a self-inflicted competitive disadvantage in precisely the fields in which the United States is competing for technological leadership at this time. The burden falls especially hard on small innovators. Large companies can rely on scale, secrecy, and litigation budgets. For startups and other small businesses, patents may be their principal asset, the foundation for attracting capital, hiring employees, and bringing a product to market. Reliable patent rights also encourage inventors to disclose their breakthroughs rather than keep them secret, allowing others to learn from and build upon them, and they help attract manufacturing and investment to the United States. PARA would restore clarity. It preserves the broad technology-neutral framework that has served the country since 1793, while replacing unpredictable judicial exceptions with a defined list of matter that Congress decides to exclude from the patent system. One clarification is essential, though. The patent laws impose several distinct requirements. Section 101 asks only a threshold question. Is this the kind of technology the patent system may protect? Other provisions determine whether the invention is new, non-obvious, and adequately disclosed. Eligibility is not patentability. Passing through the gate does not guarantee a patent. PARA is only about eligibility and leaves the patentability standards unchanged. The American patent system is a powerful engine of investment and growth, but only when its rules are clear, predictable, and properly balanced. Today, at the threshold, they are not. Congress should decide what belongs in the patent system and give American innovators the confidence to invest, to build, to disclose, and to keep the next generation of breakthroughs here at home. Thank you, and I look forward to your questions.
Thank you. Just at the outset, I had the great privilege of meeting Senator Graham a few times in my career, and I just wanted to briefly say that I join with countless Americans in offering my deep condolences to Senator Graham's family and to his friends and his colleagues for your tragic loss. Chairman Grassley, Ranking Member Durbin, members of the committee. My name is John Lee, and I'm the Senior Director and Head of IP Policy at the Computer and Communications Industry Association. Our members include some of the most innovative and prolific patent owners in the world, and they depend on a strong, balanced patent system to support innovation, protect IP, and encourage economic growth. It's a great privilege to be invited to testify here today, and I appreciate this opportunity to share our insights on this important topic. In my opening remarks, I'd like to focus on three key points: predictability, innovation, and protection. First, predictability. Now, despite some claims that the sky's falling when it comes to patent eligibility, the current state of that law in the United States is cogent and consistent. And how do we know that? Empirical data has revealed that patent eligibility decisions today are remarkably reliable and are seldom reversed or even draw a dissent on appeal. A recent study in the Iowa Law Review found that since 2012, district court decisions on patent eligibility have been affirmed more than 85% of the time. And decisions from the USPTO have been affirmed more than 95% of the time, usually unanimously. This and other data shows that courts understand the patent eligibility rules and apply them accurately to reach the correct result in the vast majority of cases. And this shouldn't be that surprising, because patent eligibility law has actually been largely consistent for over 170 years. Which brings me to my second point, innovation. Consistent, predictable patent eligibility rules have contributed to more than a century of American innovation and technological leadership. And more importantly, current law continues to support robust innovation, including in many of the areas we've been talking about already, like artificial intelligence. If the current patent eligibility framework were suppressing innovation, as some say, we'd expect to see it reflected in the data, but in fact, we see the opposite. For example, the USPTO issued approximately 50,000 artificial intelligence patents last year alone. It's almost double since the Supreme Court's Alice decision. R&D spending has also increased in that time period, including in the industries most affected by Section 101, such as software, including AI. Venture capital investment in AI has also skyrocketed, with the United States receiving 75% of global VC funding in the AI sector just last year, a total of about $200 billion. Importantly, the United States received about 12 times as much VC funding in AI as the EU, which came in second place, and 15 times as much as China in third, which casts doubt on those who claim that the Supreme Court's Section 101 cases are disadvantaging U.S. companies. And that brings me to my third point, protection. One of the ways patent eligibility rules contribute to innovation is by shielding innovative U.S. businesses from low-quality patents. Without reasonable limits on patent eligibility, litigation brought by rent-seeking patent assertion entities is likely to rise. Patent assertion entities often wield low-quality patents on abstract ideas, like sorting or organizing information, with only token recitations of generic computers or devices. It's exactly what Section 101 is designed to address. Section 101 protects U.S. businesses targeted by such low-quality patents, which frees resources and reassures investors to boost innovation. For example, a recent study found that VC funding to the industries most affected by the Supreme Court's Alice decision actually increased by 42% after the Alice decision. Now, this study also revealed that the reason for that increase was directly related to the protection provided by Section 101 against spurious litigation on low-quality patents. In closing, we are living through one of the most consequential periods of technological advancement in our nation's history, with American leadership in areas like artificial intelligence, biotechnology, and advanced computing reshaping our economy, society, and the world. Section 101 is part of that success due to the three key points about patent eligibility that I described: predictability, which boosts innovation, including by protection of U.S. businesses, all creating the balance that the patent system needs to continue promoting these and future innovations as it has for well over a century. I commend the committee for taking a thoughtful approach to understanding patent eligibility, and thank you for inviting me to testify on this important topic.
Chairman Grassley, Ranking Member Durbin, and members of the committee, thank you so much for the opportunity to be here. Before I get started, I also want to join others in saying I'm deeply sorry for the loss of your longtime colleague and friend, Senator Graham. And Senator Durbin, thank you for sharing your personal stories. My name is Sue Peschin, and I serve as President and CEO of the Alliance for Aging Research. At the Alliance, we are changing the narrative to achieve healthy aging and fair access to care. Personally, I'm also a family caregiver to my mom, who is 85 and lives with kidney disease, arthritis, and dementia. Today's hearing is not an abstract policy debate for older patients and family caregivers like me. This is about lives, choices, and hope. It's important to understand why passage of the Bipartisan Patent Eligibility Restoration Act, or PARA, has become urgent. For 15 years, the U.S. patent system has struck down thousands of patents and failed to protect some of the most transformative innovations in diagnostics, not because they weren't new or useful, but because a series of Supreme Court rulings created confusion when broadening patent ineligibility and invalidation. The problem is especially severe in medical diagnostics. The Supreme Court's expanded exceptions for laws of nature, natural phenomena, and abstract ideas have made many diagnostic inventions ineligible for patents. As a result, the Patent Office often rejects applications for methods that detect disease, measure biomarkers, or convert biological discoveries into practical clinical tools. A 2022 study in the Washington and Lee Law Review found that within only 4 years after one of the key cases, investments in diagnostics fell more than $9 billion short of what it otherwise would have been. The cost of lost diagnoses for families is why the Alliance for Aging Research strongly supports PARA. The bill would restore clarity to the eligibility section of the Patent Act so that inventors of medical discoveries can reliably make their way from the lab to doctors and their patients. And I want to note that patent eligibility doesn't guarantee patent approval. It just lets the patent office consider an invention. Without patent protection, many of these tests are never developed or they sit on a shelf. One of the clearest examples is in Ariosa Diagnostics versus Sequenom. Sequenom developed a non-invasive prenatal test that could detect fetal abnormalities from a simple maternal blood sample, sparing moms and babies the risks of amniocentesis. It was a genuine scientific breakthrough. Yet the Federal Circuit invalidated the patents. Judge Richard Lynn stated in his concurrence that the invention was exactly the kind of advance the patent system is meant to encourage and protect. But the Mayo decision compelled him to strike it down, and he actually called on Congress to resolve the confusion. A similar situation arose when university researchers developed biopsy tests that could predict brain metastases in melanoma patients. But patents on these methods were denied under the Mayo and Myriad standards, forcing researchers to abandon their efforts. And as a result, many melanoma patients learn their cancer has spread to the brain after the fact when they may only have weeks to live. PARA would largely eliminate those barriers and let those diagnostics be judged under the normal patentability rules. What we stand to lose in the near future is as concerning as what patients have already lost. Researchers are developing detection tests that have the potential to identify several cancers at once through a simple blood draw. These tests look for patterns in DNA and protein markers that can indicate the presence of early-stage cancer cells. Catching these cancers earlier will improve survival rates and reduce the burden of treatment for older adults. The promising work and development for biomarker-based diagnostics in Parkinson's is also critical, as seniors facing Parkinson's often endure years of visiting doctors before receiving a diagnosis. And today, there's no single definitive test. This is exactly the kind of innovation America should be leading. But if diagnostic patents remain unpredictable in the US, investor capital will move elsewhere. Members of the committee, it's encouraging to see bipartisan leadership on this issue. There's shared agreement that something's wrong, and there's shared commitment to fix it. On behalf of the Alliance for Aging Research, older patients, and caregivers across the country, I respectfully urge this committee and Congress to pass PARA before the end of this year. Thank you so much.
Thank you. Dr. Leonard.
Chairman Grassley, who is not here, Mr. Tillis, Ranking Member Durbin, and other members of the committee, my deepest sympathies to all of you who are grieving the loss of Senator Graham. Thank you for the opportunity to testify today. My name is Debra Leonard, and I have spent my medical career developing and overseeing clinical genetic testing used to diagnose disease and guide treatment. I want to share with you my experiences with gene patents prior to the Myriad decision. The University of Pennsylvania Health System received 7 gene patent enforcement letters between 1997 and 99, and again in 2002. The enforcements stopped my laboratory from performing 4 of our tests that we had been performing, and another clinical laboratory from performing one of their tests. We obtained a license to perform the other 2 tests, one of which led to increased costs for our patients. The medical consequences of gene patents are many. If testing for a disease is monopolized by one company, that company sets all the rules for access to testing, such as not accepting certain forms of payment or not performing prenatal testing or testing for other purposes. The company can charge any price. The company decides how the test will be performed, which can result in incomplete testing. We lose the innovation in testing methods that happens when many laboratories are performing the test, which often results in tests that are faster and at lower cost. Healthcare systems pay for the added costs and time of shipping specimens for testing, One company obtains all the specimens from across the country, thereby limiting further research on the disease and testing methods. A gene patent holder may allow broader testing, but charge any level of licensing and royalty fees. Please understand that in the current medical practice, we routinely test many genes in a single test or even the entire genome. Therefore, elimination of one or more genes by one or many patent holders makes the test incomplete or requires multiple tests, which increases costs. By contrast, the University of Michigan gave free licenses for their patent on the most common variant that causes cystic fibrosis to any not-for-profit clinical laboratory performing the test for their patients. My point is that a gene patent holder has the legal right to totally control the use of the gene without regard for the impact on patients and medical care. Physicians are increasingly using genetics in healthcare with amazing innovations. We can sequence a sick newborn and parental genomes, identifying the genetic cause for the sickness in the baby in about 25% of the babies. For cancer patients, we can identify the genetic changes or biomarkers causing a patient's cancer to grow, which can allow treatment with genetically targeted therapies that achieve cures and remissions more successfully than standard chemotherapy. I could go on and on about all the incredible advances we've seen in genomic medicine since 2013, but the important point is that all of this success occurred under the current patent eligibility framework, not despite it. We continue to reward true innovation through patents on novel technologies, therapies, and laboratory methods, while ensuring that the building blocks of biology remain available for researchers, clinicians, and patients. Having experienced both worlds, I can say with confidence that the current framework serves patients and drives innovation far better than the one that existed before AMP-V Myriad. I want to be very specific about my concerns with PARA. We have a fundamental disagreement in that the medical community holds that any part of the human genome, any disease biomarker, any pathogen genome should not be patent eligible. We are not opposed to patenting any innovation or invention that uses a sequence found in humans or pathogens without then claiming a patent on the basic sequence or biomarker. These foundational building blocks needed for medical care should remain available for everyone for innovation and invention. Please do not go back to dividing up the human genome by patents that restrict medical practice, increase costs of care, and limit patient access to life-saving tests and therapies. To be clear, PARA is bad for patients, bad for healthcare, and bad for innovation. Thank you for the opportunity to testify, and I look forward to answering your questions.
Thank you, Dr. Leonard. I noted during the opening statements there was a lot of note-taking, so I'm looking forward to the debate round that'll end after my other colleagues have had a chance to ask questions. Real quick one from each of you. Do you believe that the court, specifically the Supreme Court, have turned Section 101 from a historically coarse filter to a fine filter? Dr. Iancu?
Well, first of all, thank you for the elevation to be a doctor. Appreciate
You should be. I've known you
appreciate
for
the
years.
honorary degree.
Had a doctor on the back end, sorry.
Yes, I believe.
I meant to say director, by the way.
Yes, thank you. Yes, Senator, I do believe that that's exactly what the Supreme Court has done.
And Mr. Lee?
Thank you for the question, Senator. Respectfully, I don't think that's the case. I think the Supreme Court's recent cases in Section 101 have been mischaracterized a bit. I think they're, generally speaking, procedural. They describe a process in which you conduct a Section 101 inquiry, but that the substance of the inquiry is consistent with it.
I got a yes and a
170
no.
years.
We'll get back to that in the debate round. Ms. Peschin?
Yes.
Dr. Leonard?
No.
Director Iancu, when you were, I did say director that time. At your time at the PTO, you issued guidance around Section 101, and I felt like the guidance did a lot of good. certainly instructed some of our thinking. But guidance alone is not going to get the job done, right? Tell us why.
Well, given the separation of powers, obviously courts are not bound by administration guidance. They do what they think is right, independent of what the administration says, and in fact, that's what they've done. I will say that that the guidance has indeed done a lot of good at the PTO and the practice before the PTO. What the guidance did, the 2019 guidance, what it did is it took the body of law that the Supreme Court and the Federal Circuit has created in this area and synthesized it in a way that examiners and applicants can understand and follow a very specific process. And the result has been in the 1 year immediately following the guidance that the consistency of decisions in this area went up by 44%. And as Mr. Lee noted earlier, the Federal Circuit affirms over 95% of decisions in this area from the PTO. So therefore, the guidance basically follows the law given by the courts. 2 points are important here. There's 2 problems with the court's jurisprudence here. Number one, it's substantive. The courts have taken upon themselves to exclude from patentability major areas of technology without Congress ever saying it should do that. It's excluding, for example, the medical diagnostics, and, for example, it's excluding the analysis of heavy-duty analysis, a technological analysis of information and data. There's other examples. If there is some exclusions of major areas of technologies that are to be done, this Congress needs to debate that and make that decision for the country. That's a substantive problem. There is a procedural problem. By the way, the substantive problem Congress needs to fix. There is a procedural problem, which is that the courts have created an inconsistent framework that is difficult to follow and predict in the court system itself. That problem is solvable by the administration for processes in front of it, like we did with the 2019 guidance. And we solved the inconsistency problem. Courts could do the same thing if they wanted to. But again, they're not bound by it. What PARA does, it addresses the substantive problem and the procedural problem, and they would do a lot of good that way.
I'm going to hold some of my questions for the second round for me. Senator Durbin.
Thanks, Mr. Chairman. Bear with me. I'm a liberal arts lawyer who spent a lot of my life in politics. I wouldn't know what to do in a laboratory. I don't know much about genetic testing, but I take it that that is one of the issues that we need to discuss. And I'll start with Dr. Leonard. When I read that the Supreme Court has said law that when it comes to striking down patents on human genes and on abstract ideas, laws of nature, natural phenomena, and abstract ideas are not patentable. That seems to be the general conclusion of the court. They go on to say, or at least in Funk and other cases, natural phenomena similar to abstract ideas are not patent eligible, whereas the application of natural phenomena in a man-made invention is eligible. Dr. Leonard, what you described was genetic testing, and you are saying that some entities believe they have a patentable right to forms of genetic testing to the exclusion of other people who want to use it. Is that correct?
Yes.
And why is that a problem?
The wording in para is such that a gene is protected as long as it remains in your body, in my body, in Mr. Tillis's body. However, as soon as you purify or enrich a gene, then it is patent eligible. I can't tell the difference in the laboratory from the genes in your body and the genes that I make in a test tube. They are identical. So basically, by saying when you make copies of a gene, you are changing that gene, you're not really. And you are controlling the medical use of essential information for caring for patients. So the basic building blocks, DNA, when I have a patient who has a mutation in a gene, that mutation exists in that patient. I simply read it. It is a discovery. It is an uncovering of what exists in a patient. It is not an invention or an innovation and should not be patent eligible. So I have no problems with new testing methods, new sequencing instruments, new long-range sequencing, which you don't know what that means, but would be highly innovative and hasn't yet reached the clinical market. So all I am asking is that those basic building blocks be not controlled by any patent holder. They can use those sequences in a patent, but then that sequence is still open for anyone to use for further invention, innovation, competition, which in medicine is so important for controlling costs, for getting better therapies, better diagnostic tests. That's what I'm asking for.
Mr. Lee, when I was a kid, people were scared to death of polio. We have a colleague who's now suffering from some long-term issues he's had with polio, and many of us knew personal stories. Along comes Jonas Salk with a vaccine. I didn't care for the shot in the arm, but my mom was finally relieved, and I realized later how important it was in my life. Dr. Salk said at the end of the day, I'm not going to patent this vaccine. I want everybody to have it. I think it's important for public health. When I listen to Dr. Leonard, I hear her saying, my research is going to be restricted by the patent rights others are claiming. Do you feel the same?
That certainly can occur depending on how the patent is scoped and depending on how you look at Section 101. Obviously, there's some views that the aperture should be increased. We've heard that. And what that would do is allow more patents on things that the Supreme Court has said are basic fundamental building blocks of research and innovation. The laws of nature, mathematical relationships that exist, these are things that are part of the storehouse of knowledge for all men, is what the Supreme Court has said. And because of that, those things have been restricted from patenting by the Supreme Court's Section 101 law. If that is changed and more of that material is allowed to be patented and thus owned exclusively by one patent owner, then it's going to be much harder to use those building blocks for further innovation.
Are you agreeing with Dr. Leonard?
I am agreeing with Dr. Leonard.
So you're opposed to the bill that's pending as written?
I think PURA has its issues and certainly could use some refinement to make sure that some of these dangers don't happen.
Thank you, Mr. Chairman.
Senator Durbin, could I clarify?
Sure.
I am not talking about research. I am talking about medical care for patients.
I see. Thank you.
Senator Blackburn.
Thank you, Mr. Chairman, and thank you to each of you. When I talk with Tennesseans, they want to make certain that we stay on the cutting edge when it comes to medical innovation and utilization of healthcare technologies. And Dr. Leonard, as you were just mentioning, talking about patient care and making certain that that care is available to Tennesseans. Director, let me come to you, and thank you for the work that you were doing. We had looked at a State Department study. China is now leading the U.S. in 57 of 64 critical and emerging technologies. Does that compute with what you hear?
Yes, indeed.
And in this, they're also leading in AI. Is that accurate?
My personal understanding is that with respect to AI is a very broad field. Many different technologies within it. They are leading in many of them, and they're neck and neck with us in others. And I believe that if we don't do something about our patent system here in the United States, we will eventually lose that race.
Well, Senator Welch and I have been on this issue of protecting intellectual property and making certain that we rein in the virtual space. We've been working on that since we were each over in the House. And we have legislation, the Leadership in Critical and Emerging Technologies Act, which would expedite patent exams for AI, semiconductor, quantum computing. So you've just touched on this. How would resolving this uncertainty that really surrounds these emerging technologies and the patent system, how would that strengthen our ability for keeping that innovation U.S.-based?
Yeah, thank you, Senator. Great question here and a bunch of issues. First of all, for the United States as a free market economy to maximize its innovation output, it needs reliable intellectual property laws that apply in a predictable way to the entire scope of technology. Right now, there are major areas of technology that are basically not eligible for patent, okay? Medical diagnostics we've discussed, but a lot of information-based technologies. And we live in the information age. And courts took upon themselves to effectively exclude from the patent system the technological processing of massive amounts of data in innovative ways. That's another example. Without that, we will have some innovation here, and we do. And there is investment in innovation, some of it, and we do have that. But if we want for the United States to maximize its potential, the only way to do that reliably in a free market economy is through intellectual property laws, which our founders understood from the very beginning. And without that, we already have fallen behind China, as you have indicated, Senator, but imminently we will fall far behind, and it will be very difficult to catch up for the rest of the century.
Let me ask you this, just following on to this and para, Section 101 of the Patent Act, the Supreme Court has refused to revisit that. Why do you think para is the appropriate solution to bring some clarity, some continuity, and some confidence to that issue?
Because only Congress can do that through statute. The Constitution empowers Congress to define the patent laws, and Section 101, for all practical purposes, was written in 1793. The 4 categories of patentability were written when Jefferson and Madison were writing laws in 1793. Congress has not changed the categories of patentability effectively since then, and courts are having a difficult time figuring out how to apply an 18th century statute to 21st century law. And I just want to emphasize how important this is for the United States. Yes, we will have a Dr. Salk every now and then inventing unbelievable technologies and dedicating that to the public. And people can choose to do that as they wish. But for the United States, if we want investment and innovation at scale, they can compete with a very determined China and others. We need reliable intellectual property laws. And para does that.
Yes. And do you agree that denying patent protection for AI innovations effectively forfeits American excellence and leadership to our competitors?
I very much do that. And more than that, Senator, what it does is, in addition to that, it concentrates technology in the big and established corporations. It allows the big to get bigger, and it also pushes development towards trade secrecy. And if anything, we want more transparency in artificial intelligence development, not less. And the patent system, a patent means to lay open. That's what the word patent means. Mm-hmm. The patent system encourages public disclosures. For all of those reasons, para would help enable the United States innovation system to maximize its potential.
Thank you. Thank you, Mr. Chairman.
Senator Coons.
Mr. Chairman, thank you for this hearing today. I have a number of documents I'd like to submit for the record. Packet of letters in support of para, a document from the Innovation Alliance on Section 101, an article and summary on AI patentability, and a law review article on the impact of patent eligibility. Congress passed the current Patent Act more than 70 years ago. defining a very broad scope for eligibility, essentially anything under the sun as made by man. And that worked fine for a half century. But as we've discussed starting 15 years ago, the Supreme Court issued a series of decisions that threw eligibility jurisprudence into disarray with new unworkable tests, with new judicially invented carve-outs, and new uncertainty. And every member of the relevant federal circuit has asked us to act to clarify it. I am eager to get this passed to unwind the hodgepodge of judicially created exceptions. And I'll have some second round questions, but let me bear down on this question about diagnostic tests and the patentability of genes. Ms. Peschin, if I could, I've heard arguments that PARA would make medical diagnostic tests less accessible rather than more accessible. As someone who lost several loved ones to pancreatic cancer, for example, this simple blood test that would allow for an early detection of emerging cancers, the melanoma passing into the brain that you referenced, very important. How does making sure medical researchers can obtain patent protections possibly lead to more breakthroughs and cures?
Thank you for the question. The Patent Act that you're referring to that was passed by Congress in 1952, the basic purpose of it was to encourage inventors to create and disclose new inventions by giving them a limited monopoly in exchange for making the invention public. Right. And that actually helps them with investment, to gain investment in order to bring it to commercial market and allow for a lot of Americans to have access to these types of tests. I don't disagree with Dr. Leonard that someone like herself, who is a specialist and wants to provide those same tests to her patients, should be able to do so. However, the inventor of those tests that devoted time and money and had investors that also devoted time and money into the invention should be able to license it to her in order to use it. And the very fact that she is able to recreate it is due to the patent system and the transparency within the patent system. So PARA, and the reason why it's so important is because what the Supreme Court cases have done is they've muddied the waters. Right. By broadening these exceptions and making it harder for the cases that have come after, so that there's a lot less predictability for inventors. And in
Dr.
order
Leonard, forgive me, I've got 2 minutes. Dr. Leonard, I hear your concerns that you've raised with PARA that it could open the door to making some inventions in genomics patentable and create barriers to research. There is an explicit provision in PARA now in the revised version that says human genes are not patentable. Would building in an experimental use or research use exception to patent infringement help address this issue? And do you have other revisions you would suggest that might help us make sure that we are not causing unintended harm to the development of critical medical diagnostics?
So I can provide later potential language. I don't want to do verbal
I understand.
Rewriting. I have not found that diagnostics have been inhibited. I know that there is data that shows that there are 175,000 genetic tests on the market now and 10 to 14 more coming on each day. It's data from Concert Genetics. I find that medical genetics is not being inhibited by not being able to patent genetic sequences, human genes.
Dr. Iancu, you've done a huge amount of work, Director Iancu, you've done a huge amount of work in this area. We've got clear disagreements. Help me understand how to square that circle and why we still might need to legislate in this area. Forgive me in the last minute.
Yeah, sure. So on diagnostics, look, like every innovation, it's a balance between incentivizing and protecting the innovation and investment in that innovation and public access to that innovation, okay? Mm-hmm. And like with anything else, you need to have the innovation there in the first place for the public to even have access. And if we're talking at scale, for the United States to be maximizing its innovation output, if we don't have the stability of the law, then we're going to miss out on technologies that we don't even know about. So for Dr. Leonard and patients and others to have access to that technology in the first place, it has to have been invented. Then after that, we can talk about appropriate access. There's licensing. There is, as you indicate, Senator, the potential for a research exemption. There are other ways to address medical pricing and pricing for the diagnostics that have nothing to do with the patent system. But the threshold question for creating the innovation in the first place, the first leg of that balance, needs to be a reliable patent system.
And you said in passing earlier, but it bears repeating for folks who don't spend their lives on this, a company has a choice between keeping something secret, protecting it as a trade secret, or publishing it for the world, laying it open as a patent. And that choice is in part driven by whether or not there is predictability in patent eligibility jurisprudence. Is that correct?
That's absolutely right. And there is lots of evidence that since the recent Supreme Court cases, Alice, Mayo, and so on, there has been a push towards secrecy, both for diagnostics, also for certain AI types of technologies that Senator Blackburn was asking about.
Thank you very much. Thank you, Mr. Chairman.
Senator Welch.
Thank you very much. You know, the conflict here is, number one, should you get a patent on something you didn't invent, which is a gene? The patent system, as I understand it, has never been used to grant that. And then number two, there's a real debate here about whether a patent system would actually stifle innovation or enhance innovation. I'm sorry, I want to make sure I pronounce your name right.
Iancu.
Iancu, okay, thank you very much. We have enormous experience here with patent holders abusing the patent system. They create patent thickets, they fight every rule, and they sue people who are coming on. And there's just overwhelming evidence that while I'm a strong supporter of the patent system, I'm well aware of the abuse of the patent system. And you said that there are ways which some of these could be worked out. And let me just say to you, let me know what they are, because I want to stop the patent abuses that are out there. Dr. Leonard, I want to go back to you. I thought you made a very good distinction here between something that's naturally occurring and where to do the research that should be available to researchers without having to pay a fee. And you also were on the receiving end of cease and desist, or I guess letters that stopped research midway. I mean, just respond to this distinction that you're making about how this legislation, in your view, would interfere with innovation in patient care.
So to be clear, I was stopped from doing clinical testing for patients. My research was not stopped. So we had to stop doing 4 tests, the 5th one by Haig Kazazian, who was also at the University of Pennsylvania. I think what is not understood is that as a pathologist, I can develop and validate genetic tests in my clinical laboratory that is CLIA certified and perform that for patients. I don't need a patent. I don't have to license patents because the genes that I'm testing are not patentable now. And that is what will stop. And that every academic laboratory.
Just walk through that very specifically, how that would stop, because that's the heart of this.
We can sequence a baby and parental genomes of a baby in a NICU, just been born and not looking right. And 25% of those patients, babies, we can find a diagnosis that allows for treatment. If not treatment, then stopping a diagnostic
just to interrupt,
odyssey.
that has to be done immediately.
Yes. In fact, it's better if it's done prenatally, but it's often done immediately. Imagine 20 to 25,000 genes in the human genome, and if even 1/10 of those are patented, then I have to go get licenses or royalty fees or rights to use that genetic information for my patient. And I became a physician to practice medicine, not to practice law. And that's what it became at the University of Pennsylvania because of genetic sequences that were patented. We didn't need the patents for protection. Companies do. And to go back to Mr. Coons with pancreatic cancer, we now, for the first time at ASCO, an oncology meeting, have a treatment for pancreatic cancer that lengthens life. And it's not as much of a death sentence. It has the opportunity to turn pancreatic cancer into a chronic disease. Innovations are still happening. Therapeutics are being developed. Molecular diagnostic tests are coming on the market. I don't understand the data being cited that it's being inhibited. Maybe in AI, in other areas, there is a real need. But right now, I am not seeing the need in medical practice for basically going backwards.
So literally, going back to that NICU example, as a clinician, you would not be able to do what is necessary for the well-being of that baby.
Oh, I might be able to after obtaining 100 or 200 licenses, each at, the license fees we were charged were $25,000 by one company. We had to pay $120,000 for another.
Yeah.
We ended up having to pay a fee per test for one test that was more than what Medicare reimbursed us for doing that test.
Right. Okay,
My
time is up, so I'm going to
Okay.
yield back, but thank you very much,
Senator
Dr.
Welch,
Leonard.
the specific exchange that she was referencing, which happened while you were not here, was about this bill having a specific provision that says you cannot patent a human gene. And some of the conditions she's describing were before the Supreme Court ruled you cannot patent a human gene. It's important to put these in a appropriate time context.
Yeah.
Senator Rono.
May I say something in response to the last
Was
exchange?
before me,
We'll
but
get to that in the debate
can
round.
you clarify for me?
No, Senator Rono, you were here first, but Senator Blumenthal, would you defer? Or Senator Rono, would you defer to Senator
I'd be happy
Blumenthal?
to defer to
Okay,
my
well-
colleague from Hawaii.
Thank you. I know that patent law is very complicated, and I also know that the Supreme Court and the Mayor and Alice decisions created a lot of uncertainty in the patent system. So I do thank Senators Tillis and Coons for coming up with a bill, which I am a co-sponsor of, that sought to create some level of predictability so that our patent system can be more useful. That's one way of looking at it, I suppose. For Mr. Iancu, you said that the Supreme Court created, or we have an inconsistent framework. Can you just explain why our patent system is an inconsistent framework?
Yes, thank you, Senator. So at least two problems at the high level. First of all, there is a substantive problem, as I mentioned earlier. The courts have taken upon themselves to exclude from patenting whole areas of technology without Congress debating that issue or permitting such exclusions. So that's a substantive problem. Second, they've created a framework, the two-step Alice framework that the Supreme Court articulated in Alice, has become very difficult to apply by the lower courts and for practitioners to understand what the outcome would be. So a procedural framework has created a lot of confusion in the space.
So do you think that the Patent Eligibility Restoration Act would help to restore some level of predictability? Would you support this act?
Yes, I do believe that PARA fixes those issues. It addresses the substantive problem and allows Congress to actually decide after a proper legislative debate what's in and out of the patent system. and it also addresses the procedural problem, and it eliminates the confusing two-step two-step process that the courts have implemented.
Another thing,
Just, if I may, very quickly on that procedural problem. One of the concerns that have emerged from the court's jurisprudence is that the courts are effectively commingling areas of patent validity. The Patent Act of 1952 created distinct areas of analysis, distinct lanes of analysis. For 101 is one lane, but then we have a separate statute for novelty, and a separate statute for obviousness, and yet another one for adequacy of disclosure and claiming. The Supreme Court's jurisprudence commingles all of those things. PARA fixes that problem.
The fact that the Patent Court has asked for clarification from the Supreme Court and they have chosen not to provide that clarification says to me that Congress has to step in. You also said that we are moving, there's a push towards secrecy. I think that is not what we want to promote at a time when sharing of information, even if maybe the patent system has its own limitations, but that at least provides some level of information that others can build upon. So moving toward forcing people, I suppose, or directing people toward resorting to trademarks, for example, is not the way we should be going, I would think.
That's right, Senator. It's detrimental for the United States in general, and it's detrimental for further add-on innovation.
So I note that Dr. Leonard, you testified that you are not. I think I note that you are not supportive of patents because of your own experience.
Oh, no.
Can you speak into the mic, please? I can barely hear you.
Well, I was speaking softly because you were still speaking. Sorry.
So in light of
the
the desire to share,
I am fully in support of patents. I just do not think that any one patent should control a human genetic sequence, a pathogen genetic sequence, an association between a biomarker and a disease. Those things are needed for free use in medical practice. That does not mean that building on understanding that a gene is associated with a disease and I'm going to make a treatment for that, that treatment should be patented. That takes a lot of effort and a lot of money. But the basic information that we use in medicine should not be patentable.
Thank you, Mr. Chairman.
Senator Blumenthal.
Thanks, Mr. Chairman. Thank you all for being here. I want to add my thanks to Senators Kuhn and Tillis for their hard work. And just try to bring back to everyday lives of people. I'm a lawyer. I know very little about patent law, I have to acknowledge. But I do know that our patent system can impact the prices that people pay for pharmaceutical drugs. And I think we can all agree that we need a patent system that works for our innovators, our companies, for their investors and researchers, but also for the everyday American who wants to buy drugs at the lowest possible prices. So let me ask you, Dr. Leonard, and others should feel free to add, what impact would potential patent eligibility reform have on patient costs and access?
So prior to the Myriad decision, Myriad charged $4,000 for sequencing the BRCA1 and BRCA2 genes that that can identify high risk of breast cancer. Today, and granted, technology has changed a lot, but today we do over 80 cancer genes for a few $100s. So Also, before enforcements from Myriad, the prices that laboratories doing BRCA 1 and 2 testing were doing were higher than the laboratories who were stopped from doing that testing. Myriad would not accept Medicaid payments because they were too low. And when I was stopped from doing ApoE genotyping in my laboratory at the University of Pennsylvania for Alzheimer's disease, by Athena Diagnostics, they charged twice the price to do that test than I was currently charging in my laboratory. So patents do increase the cost of care, rightfully so when there is a huge investment like creating a new diagnostic that is able to treat pancreatic cancer or other cancers or things like that, or the CRISPR technology that treats a baby in utero for a genetic disease. I mean, there are technologies that need to be protected by patents.
Senator Blumenthal, if I may, the issue here is not about whether patents are allowed or not allowed. It's about what level, at what level of innovation is that allowed. If you allow a patent on the fundamental building block, the abstract idea, the law of nature, you're going to only allow one patent owner to control everything to do with that law of nature or mathematical relationship or whatever it is. So that is one way to do it. The way it's currently done is that if you can take that law of nature or that mathematical formula and apply it to a particular diagnostic test or a particular device or a particular product, you can get a patent on that. And that promotes innovation, right? Because as you develop a product, you can benefit from that patent. But it also permits more innovation because there are more products, more competition, more choice, more broad-based innovation. And so that is the current system, and moving towards a system where there's more patents of higher level basic building blocks is what we want to avoid.
I would like to respond, sir. The concern that Dr. Leonard brings up around bad actors, who are not allowing licensing or sending threatening letters and all of that, as an advocacy organization, we would be happy to work with you and bring that out into the sunlight and put pressure on them. But I don't want that to be a reason why we don't push forward with this legislation. There are bad actors in every aspect of healthcare and folks who abuse things. But the reason why people look into creating new diagnostic tests for a lot of the conditions that we care about, including Alzheimer's disease, is because there is investment in them. And it takes years, and it takes study and going to the FDA and a lot of work. And the patent becomes public and allows individuals and other clinicians like Dr. Leonard to replicate those tests and be able to use them in their practice. So there is benefit to it. And when the remarks that keep saying everything is fine, there's a lot of different tests, I just want to bring up very quickly a study by SMU professor David Taylor. He demonstrated that there were negative impacts on investment-making decisions, and he interviewed 475 venture capital and other private equity investors to study the impacts of the Supreme Court's decisions, and he found 74% of investors considered patent eligibility to be an important factor when their firms decide to invest in companies developing new technology, and 62% agreed that their firms are less likely to invest given the unavailability of patents.
Well, I appreciate those points. The best laws on the books can be abused, but we want to try to achieve a system that prevents, in effect, profiteering and manipulation of the system. When I was Attorney General of the state of Connecticut, I sued companies because they engaged in extending patents by changing the color of pills or whatever. But we want a system that is as immune as possible to abuse and protects the costs of discovery and research. Obviously, failing to do so would discourage it. But I think my feeling is there is just so much more that can be made available to patients at lower cost if we have some reform in the patent system.
Senator Schiff.
Thank you, Mr. Chairman. And I want to join my other colleagues in acknowledging the loss of our colleague Lindsey Graham. Had the great pleasure of traveling with Senator Graham many times, and just so treasured his sense of humor, his knowledge, his relationships with leaders around the world. He was a great traveling companion. He was a great companion and colleague, and we will miss him dearly. So what I'm most focused on in this legislation is the overturning of the Myriad case. And I'd like to ask you all to comment on it. And I just pulled up the opinion here. And the summary says, held, a naturally occurring DNA segment is a product of nature and not patent eligible merely because it has been isolated. But cDNA is patent eligible because it is not naturally occurring. That seems like a rational conclusion to me. Why is, for those of you who think this case was wrongly decided, why is this decision flawed? And I'd ask you all to comment on what's obviously a balance here, which is we need investment in these new tests and treatments on the one hand, and we want to incentivize it. And by providing a patent, you have security for that investment and a way to encourage investors. At the same time, if you go too far, then you give companies a monopoly on tests and treatment that raise the cost for everyone and make it potentially prohibitive to discover disease. So, but tell me why those of you that think that was improperly held and needs to be overturned, why that holding is erroneous.
Should I start, Senator? I'm happy to start. Thank you for the question. Well, as you may or may not be surprised to know that I don't think that PERA overturns the result of the Myriad case. As a matter of fact, PERA effectively codifies the result of the Myriad case. Indeed, PERA expressly says that things that occur naturally, or in particular, human DNA as found in the human body, including human DNA as found in the human body that is isolated, which is the first half of the Myriad holding, should not be eligible for patent. PERA expressly states that. On the other hand, Myriad, as you have indicated, Senator, does say that if the DNA is modified by humans, in that case, there was what's called cDNA, basically the exons were taken out, and in any event, don't need to get into the details, but it was modified. The Supreme Court said that is eligible. And PERA, likewise, states that affirmatively. So the bottom line is, all in, the result of Myriad is expressly codified by PERA. The one problem with all these Supreme Court cases combined is the methodology of how they get there, which has resulted later in the lower courts misapplying it, expanding it broadly, and so on.
And do all of you agree that that the bill just codifies the Myriad decision? No? Let's see.
Well, I agree that that is the aim of the bill. I understand that Dr. Leonard and AMP, her association, have some concerns about language that could refer to laboratory processes. And before you arrived, Dr. Leonard talked about some potential language that they could propose, which I think everyone here would be open to, because we want to get this over the finish line. And the aim of this is to make it clear that human genes, whether isolated or found in their natural state, are not patent eligible, and we all agree on that. So if there is something that needs to be done, rather than sort of rallying opposition to the bill, let's work together to clarify and make sure that absolutely it's codifying Myriad.
Mr. Chairman, may I allow the other witnesses to?
Oh, please do. Senator Schiff, I'd actually told Senator Durbin if he wanted to leave, I wouldn't begrudge him, because I'm considering this part to be the debate round. You know how we've done it in the committees. I know Senator Coons has. There's some issues where I've noted people taking notes or furrowing brows, and I just believe in open, honest communication to get the most out of these hearings. So please continue.
Thank you. I'd love to hear from the other two witnesses who haven't spoken to this.
So I think, I don't know if this was intentional or just an oversight, but just one example as to why there might be some confusion about this. So you had noted that in the summary of the Myriad case, the Supreme Court ruled that isolating a gene does not make it patent eligible. It is still a human gene, a product of nature, and can't be patented. In the portion of PURA, for example, that talks about human genes, it says that something that's purified or enriched counts as being modified. It does not say isolated. Later, when it's talking about a different type of invention about natural material, it does say isolated, purified, enriched would make it modified. So I don't know if there's some, if that was intended to be different or what have you. But in any event, I think more importantly, the issue with these Supreme Court decisions, there's a lot of, you're hearing from both sides, that some people think that they were correctly decided, some people think that they've created a lot of uncertainty and were poorly decided. And what I would say to that is, we have hard data now about whether that's the case or not. And there's hard data that shows, there was a study that studied every single patent eligibility case at the Federal Circuit since the Alice decision. And that found that 85% of decisions by district courts in applying that law were affirmed. If it really was so unpredictable and so uncertain, you would expect that there'd be a lot of variability. Judges don't know what to do, it's a mess, they do their best, and the Federal Circuit doesn't know what to do, it's a mess. You would not expect to see that level of uniformity in the data, but that is what we see. And so I think that data shows that, in fact, after more than a decade of experience, the proof is that it's predictable, it's consistent. In fact, it was one of the most predictable patent law issues that the study looked at.
And Doctor?
So the problem is that purified, which, as John points out, is still in para, is the same thing as isolated. So, and in para, if I'm quoting it correctly, there are many multiple negatives, like an unmodified gene is now modified if it is purified or enriched. So that means that it becomes patent eligible as soon as you take it out of the human body. I can't practice medicine to look at the genes in a patient when they remain in the patient. So I need to be able to purify or isolate, and if that then makes it patent eligible, that means I will be stopped from doing that by some patent holder on that genetic sequence. cDNA is a little more complicated in that cDNA is copies of messenger RNA, which is made from DNA. So that's I now started talking Greek, sorry. So cDNA is a whole other issue that we can get into if you really want to go there. But I would ask that somehow in para, with language that maybe we can provide, the human genome, pathogen genomes, relationships between variants in genes and diseases not be patentable. They can be a building block, as John says, for other patents on top of that. But that way we can use this information for medical practice.
And you fear that as it's written now, it would give patents in an overly broad way that would restrict what you can do with DNA.
Yes.
Actually, we have Senator Hawley coming, and we'll let him ask questions. Senator Hawley, you're coming in the middle of our debate club, but we're gonna come back to you. But a part of what Senator Coons talked about was getting straight to the line. The whole reason that we've had fit-be witnesses and endless work groups is to try and address the legitimate concerns. So we'll come back to that. But for now, because I also want to ask the basic question you all can be thinking about. This is the eligibility phase of the process. I'd like for some people to talk about examples of whether sections 102 and 103 would knock out the patentability, even if it was eligible. So be thinking about that. Senator Hawley.
Thank you very much, Mr. Chairman. Thanks for calling this hearing. Thank you to the witnesses for being here. Dr. Leonard, I wanted to start with you if I could, and I wanted to just ask a question or two about prescription drug prices in the United States. Everybody I know, every Missourian that I know, heck, everybody from any state that I know is struggling to afford prescription drug prices in this country. It seems that they do nothing but go up and up and up. Drug prices in the United States are significantly higher than our closest peer nations. I think we've got a poster here that I'm going to put up, an analysis from the RAND Corporation back in 2024 comparing U.S. brand name drugs, prescription drugs, to those of other two countries. 32 countries were compared in the study. We've got here Canada, France, Germany, Italy, Japan, Mexico, and the United Kingdom. And it shows how much more the United States, our prescription drug prices, how much our prescription drugs cost on average than the prescription drugs in those countries. In Canada, our prescription drugs are 324% more than the Canadians, 445% more than what the French pay, 464% more than Japan, and on average in this 32-country index, 422% more. There's the cost of insulin. The average United States insulin manufacturer price per unit is $98.70. In Australia, it's $6.94. It's $12 in Canada, and in the UK, it's $7.52. Now, this just seems to me totally outrageous and totally unaffordable for every American. Somebody is getting rich off of this, and it's certainly not the American people. So Senator Welch and I have introduced a bill called the Fair Prescription Drug Prices for Americans Act that would stop Big Pharma from selling drugs in the United States at a higher price than the international average. That there would be stiff penalties for those who violate that rule. My question to you is, do you have a view on legislation like that, or what we're going to do about the cost of prescription drugs more broadly? I think that this is a crisis that the American people cannot afford to go on any longer, and it's time that we took action on it. I'm just curious, in your professional opinion, what your thoughts are on this.
Well, this is totally off the topic, other than prescription drugs are usually patented. I think it goes back to the basic problem in the United States. If you look at any of those other countries, they have national health care. I'll stop.
Anybody else want to comment on this?
Sure. Thank you. I don't disagree with what you put up at all. We care a lot at the Alliance for Aging Research about affordability, particularly for older adults. And I would love to meet with you and talk about the work that we've previously done on affordability and prescription drugs. Patents generally aren't the reason that prescription drugs cost so much. In fact, without them, a lot of treatments wouldn't exist. So we wouldn't really have anything to argue about if we didn't have the drugs themselves. Patents really encourage investment in new therapies and improvements in existing ones. So happy to talk to you about affordability issues.
But don't you think that we can find a way to protect our patent system, which I'm all for doing, provided that it's not gamed any further by the pharma companies to keep prices high? And let's be clear, the pharma companies are absolutely gaming the patent system in order to keep prices high. I mean, I think there's no doubt about that. You can't look at these numbers and not think that our pharma companies are not ripping off consumers in the United States of America.
Good night.
And maybe that may not be the square topic of this hearing, but I can tell you what, it's what the American people care most about.
Yep.
They care about this right here. They cannot afford their prescription drugs. And until this Congress does something to bring down the cost of prescription drugs, we're just whistling Dixie. I mean, the American people don't care about that. They care about what are you going to do to make healthcare cheaper in this country.
That's right.
And so far, this Congress has done precisely zero to make healthcare cheaper in the United States of America and nothing to bring down the cost of prescription drugs. Yes, sir.
Thank you, Senator. I don't think you'll hear a lot of disagreement here about needing to reduce drug prices under the proper circumstances, but that should not come at the cost of innovation, because the cost of a drug that's not invented and brought to market after lots of research and development is basically infinite. And the cost on the American healthcare system and the taxpayer of having diseases go untreated is extraordinarily high. So that's point number one. Point number two, there are two sides of the chart that you're showing. The main problem is that there's tremendous free riding overseas on American innovation. And as a result of that, the cost of innovation is borne disproportionately by the American taxpayer. So instead of engaging in a race to the bottom and decimating the American innovation ecosystem, we should work hard to force our trading partners to bear their fair cost for that innovation.
Well, the race to the bottom, I mean, the American innovation system when it comes to prescription drugs is not going to do American patients much good if they can't afford their drugs.
The reality is that 9 out of 10 prescription drugs in the United States are filled with generic substitutes, far higher than the average in the OECD. In the end, I agree with you, but the way to do it is to force our trading partners to bear their fair cost, which will decrease the cost to the American taxpayer.
I wanted to say to the various companies who hold the patents on these various drugs and are selling them that you can set whatever price you want in the international market. It is a global market, but you cannot price gouge the American people.
Well, there are foreign governments that prevent that, and that's off the topic here, and I'm not an expert in that issue.
Well, why shouldn't we prevent it? And this is my point. I mean, why are we allowing the American people to get the shaft here? Other governments are protecting their citizens from high drug prices, but we don't. And we're told constantly, well, that's the price of innovation. So you just have to suck it up, Americans, and pay the cost on, oh, you can't afford your drugs, you can't afford your insurance, you can't afford to go to the doctor anymore. But we've got a great healthcare system. It's all innovative. It doesn't do people much good if they can't actually get to the doctor. You're going to say something, Mr. Lee, and then the chairman, I think, has had about enough of me.
I want to get back on, and if it relates to para, you can speak. If it relates to the broader issue, I think it's something that we've debated ad nauseum. And quite honestly, the cost of a drug and a therapy that could save millions that was never invented is zero. Yes. Okay? I was a research and development manager back in the mid-'80s. When I started looking, it was in technology. But when I had a smart person come into my office and say, we have a promising new technology, I need thousands of dollars to invest in it to bring it to market, my first question was, number one, do we have is it technologically viable? Number two, are we going to have a long enough horizon to recover our investment to make this work? And if the answer was a question, that R&D person went back to R&D and worked on another project, and I didn't authorize that project. Now, if you want a real working example on when government gets wrong, and this is all I'll do before I get back to para, on artificial drug pricing, go listen in to some of the minutes of the board meeting notes about 6 months after the Inflation Reduction Act was passed, when they noted that 60% of their small molecule research budget had been slashed. Then what happens to the people that were hoping on that innovation to save them? So the problem with Washington is we have an oversimplified approach to solving a legitimate problem. It is not just about telling the pharmaceutical companies to cut their prices, unless you want to cut the enormous benefit that they have to the American people. When people get sick anywhere in the United States, they're more likely going to want to come to the United States, or anywhere in the world, they're more likely to want to come to the United States more than anywhere else because we do invest and we do innovate. If people want to have a serious non-political discussion about reducing healthcare prices, you need to get everybody in the healthcare value chain into the barbershop, and everybody needs a haircut. But if you do it arbitrarily and you're driven politically, you're going to be having the same discussion 20 years from now, and the patients of America suffer. You need to bring in the litigious environment that we have here, the regulatory environment that we have here, mirror that against other countries. The cost to actually provide the drug in various jurisdictions is a meaningful part of that discussion. So if we want to have that discussion, a non-political, really nerdy, detailed, lots of work sessions, count me in. But if we want to have the beat up anybody in the value chain discussion, boy, there's a long list of people that get harmed if we don't get it right. Now,
Mr.
debate
Chairman,
club.
might I intervene for 1 minute?
Yeah,
could I ask?
But I'm not here. I am here, actually, ironically.
But Mr. Chairman, Mr. Lee, Mr. Lee was going to answer my question.
Ironic, and Mr. Lee, if it does relate to para, if it moves in, if it somehow relates to para, please proceed.
Because this bill is not related to the issue that the
Exactly,
senator,
but I'm just trying to see how
senator
you
is the
relate
lead
that to para.
co-sponsor on the bill that would address
I don't-
the issue that he wants to talk about, but that's not the topic of this hearing.
Yeah, I understand. But so, Mr. Lee, to the extent that you can respond to Mr. Hawley's question in the context of how it relates to the plain text of the para bill, rock on.
All right, I will do my best. I promise I will get to PURA. And this is an issue that it's actually not just limited to pharmaceutical drugs. High prices are something that Americans are really struggling with in a lot of different areas, pharmaceutical drugs being one. And what I would say is that we really can have it both ways. We can have a patent system that incentivizes innovation, and then we can have patents that have limits that already exist in the law, limits on those patents to make sure that, you know, whatever benefits.
But Mr. Lee, you did hear that the vast majority of drugs being dispensed are generic equivalent. You know how they become generic, right?
Right, and,
Okay.
and that's a situation where it's working, where a generic was able to come into the market. The limit on the patent, whether it's the temporal limit because it expired or because it shouldn't have been granted in the first place and it was invalid and it was invalidated at, say, the Patent Trial and Appeal Board or someplace like that. That's examples where limits are being enforced and patents are not overextended beyond where they should be.
I'm not dismissing what Senator Hawley says in terms of a pricing problem, but somebody who's worked in this space for a while, served clients in this space, and have talked to the hospitals, the patients, the pharmacy benefit managers, the insurers, the healthcare providers. All of those are in the value chain. All of them are part of the solution, and if we go at it in pieces, we're going to have a suboptimal result where patients suffer.
Was that the extent of your answer, though, Mr.? I'm just trying to get an answer to my question, Mr. Chairman. And is that it?
Mr. Lee, would you submit that for the record? Would you submit a response for the record?
Mr. Chairman, you basically just testified. I've never seen a hearing where the chairman testifies for the witnesses. I know you don't like my questions,
Mr.
but
Hawley, I've never seen a hearing where the entire discussion was off the topic of the bill. Do you have any specific questions on para? Because this is actually a committee hearing on trying to improve patent eligibility. Do you have any questions on that matter?
I've got these questions that I can ask any question I want, Mr. Chairman.
You can within the 5 minutes.
And you just talk through his answer at the end. I just wanted an answer to my question.
Mr. Hawley, Senator Hawley, your time had expired when we continued the discussion. Now, I want to get back to the basic question of 102 and 103 affecting, after you go through the eligibility lens, affecting the actual patentability. Director Iancu, would you like to start?
Indeed. As we discussed, there are at least 4 statutes that govern whether a patent should be issued. Number 1 is Section 101, eligibility. But then after that, we have 3 other statutes. 102 on novelty, 103 on obviousness, and 112 on the appropriate scope of disclosure and claiming. Para affects only the first one, Section 101. After that, we need to go through the rest of the statutory lens. If we talk about a DNA sequence that is in the human body, okay, this human genome has long been fully identified and published. There is So, at a minimum, if somebody says, I have discovered this sequence, it will fail even if it gets past Section 101, but it wouldn't, by the way, because para excludes that expressly. But let's just assume hypothetically that it gets past that, it would still fail under the novelty or obviousness statutes. Second point, Senator, I do want to mention, because it's been said multiple times here, that somehow the U.S. diagnostic market has not been affected. Sure enough, there is still innovation. Obviously, there is some innovation, but it's not at scale. There are studies that show that in the year following Mayo, the diagnostic market in the United States has been reduced by $9 billion. There are other studies that show that the vast majority of the diagnostic market in the United States is moving overseas, and in particular, China. These decisions have real-world consequences when we speak about scale.
Okay, Ms. Peschin, you wanted to react earlier, if you remembered, I actually noted it. Did you want to bring up a point, I think back with the interchange with Senator Coons? You said if you may, actually it was Senator Blumenthal.
Yeah, I think what has struck me is it's been brought up a couple of times by Mr. Lee, this idea that the courts have been consistent over time, that is a reflection that things are going okay. And I just wanted to bring up, there was an interesting piece that is very readable for folks who want to learn more about this. It was in The Hill, and it was from retired federal court judge Paul Michel and Kathleen O'Malley that referred to the study that he keeps talking about, that the courts just sort of follow each other. They stated together that this review was misleading, that it's true that expert lawyers can predict the likely outcome of Section 101 disputes, which generally involve finished products that have already been brought to market. But startup companies are not making research and investment decisions based on finished products. So I think it's just a really important point that following if the courts are just kind of mirroring each other because of the unpredictability and validating each other on that, that's not a sign of how things are going. And in fact, I think some of the other studies looking at venture capital and the decrease in investment and the $9 billion, those are real reflections.
Mr. Lake.
Thank you, Senator. So I'm not familiar with the particular comments from Judge Michel that were quoted, but what I would say is that the study conducted in the Iowa Law Review looked at every single Federal Circuit 101 decision from, I believe, 2012 to 2023, over a decade. It didn't distinguish based on finished products or any other kind of product, every single case. And it found that it was extremely predictable. And so, I mean, the 101 inquiry, I mean, I was a former judge. I decided 101 cases in my court. I could tell you the 101 inquiry is difficult. It's a complex inquiry. It's hard. But is it unpredictable? Is it uncertain? Is it unworkable? The data shows that that's not true. These decisions are being affirmed at an extraordinarily high rate for patent issues. And so it is consistent.
And Dr. Leonard, I really do genuinely hope that you all can take a look at some of the language in your unique case. I think you even heard Ms. Peschin, who's on the other side of the underlying issue, reach out to talk about the other issue of people being opportunistic and maybe charging too much. That's separate. But for your particular purposes, if you do have language, we would be more than welcome, or we would warmly receive any language that would address some of the behaviors that you're seeing there. But that's the whole point of this process, folks. I know from the perspective of industries that are comfortable with the status quo that change is concerning. But I believe that there are several innovations, several inventions that will not come to be in this jurisdiction if we don't recognize some of the modern challenges that we have. But I'm not one who wants to throw a baby out with the bathwater. I want to get this right. Those who are interested in advancing the legislation and in constructively bringing forth use cases that say, how do you address for that? We're all about that. for people who just want to argue against any change in favor of the status quo because that it benefits their particular sector without looking at some of the challenges that are created if we do nothing, should kind of look in the moral mirror and try to figure out a way to get it right. Now, it may be at the end of the day, when you come and show me all the pros and cons, that I could be convinced not to push as hard on my own bill. But right now, I believe in my heart of hearts, we're moving in the right direction. We want to engage the stakeholders. Many of the stakeholders who have concerns with this are people I worked in industry for years. I get it. But let's be smarter. Let's be innovative ourselves and try and figure out a way to get the language right so that we are that jurisdiction that people look to like they have since the founding of this country. Senator Coons, any comments?
Thank you, Mr. Chairman. Just 3 quick topics, if I might. Mr. Lee, you've cited repeatedly now the Iowa Law Review study about the Federal Circuit and its affirming invalidation on Section 101. Consistently bad would be my rejoinder. They may be consistently applying, but Ms. Peschin cited a very specific case where a potentially patent-eligible innovation that would have given early warning that melanoma was crossing the blood-brain barrier, the relevant judge said, I wish I didn't have to invalidate this, and repeated the call to Congress to legislatively fix it. So it may be being consistently applied, but in Mayo, the court cautioned, this is in dicta, but that too broad an interpretation of its exclusionary principles could eviscerate patent law. And in the years immediately following, 5 years following it, district courts invalidated 60% of patents challenged as ineligible, and the Court of Appeals for the Fed Circuit invalidated 90%. They may have been consistent, but I would argue consistently bad, and part of the impact is costs. Drug costs, Mr. Peschin, are a central question that never got, I mean, we had 2 different senators sort of try to ask the question, but in the exchanges with Senator Blumenthal, it was all about medical diagnostics, not about the cost of pharmaceuticals. And Dr. Leonard, when my colleague from Missouri sort of launched, you said, this is off the topic. My core assertion would be that in terms of the patentability or patent eligibility of drugs, of pharmaceuticals, PARA has almost no impact. It is very rare for pharmaceuticals to be invalidated. There is a separate issue, which is patent thicketing, patent hopping. Senator Hawley co-leads the relevant bill with Senator Klobuchar. I support it. But these are, am I correct that these are unrelated? What we're trying to do here in eligibility reform and legislation that would address abuses of the patent system to raise patent prices. Ms. Peschin, briefly. And then I have one last question.
Yes, very much so. It has a disproportionate impact on diagnostics, and you're correct.
Okay. And there was a lot of smeariness on this topic because medical diagnostics, in which you are an expert, and pharmaceuticals are basically quite different. And a lot of the senators who were here briefly failed to grasp that point. I'll just reinforce what my friend and colleague, Senator Tillis, said. Doctor, if you've got a different way for us to get at purified, there are slight differences in human genome versus any genome, and we were trying for the best language. And so if all 4 of you would look at that particular piece, I think what we're doing in PARA is codifying the Mayo decision that you cannot patent a human gene. But I asked you earlier about a medical research exception. We are out of time, and there's a vote we have to get to on the floor. I am wide open to, and I believe my friend and colleague is as well, refinement of this language, but this has taken an exhaustingly long time to get to, and this Congress is just about over. Director Iancu, my last question to you. We spent no time on national security. This was all about drug prices, which really wasn't that relevant to the topic. I'm really worried as the senior Democrat on defense and intelligence appropriations that we're falling behind on AI, on blockchain, on 5G. How would PARA shore up our global competitiveness in critical national security research?
I share your concerns, Senator. PARA, first of all, would bring back into the realm of patentability areas of technology such as information processing in very complicated technological ways that the courts are currently excluding. That's just one example. Same for diagnostics, where we as a nation depend a lot on China and other foreign countries. From a national national security perspective, we have to do everything we can to maximize the innovative potential of the United States. And in a free market society where inventors and investors have the free will to invest as they will, or not invest at all, or invest in other countries, the only way that we know how to do that at scale is what the founders recognized. It is with a reliable intellectual property system. And PERA goes a long way in that direction. There are, for sure, other things that need to be improved in the patent system. But PERA is at the threshold, Section 101, the first thing that gets analyzed, and that is something that has to be codified by the rule of law.
Senator
I
Coons, I think it's Dr. Leonard, if you'd like to speak, I
please
think
don't
it would
make me
be
a senator.
fitting to have Mr. Lee have the last word.
Mine is a quick clarification.
We've got to vote.
You want language that will
Yes.
codify myriad.
Yes. Did I say Mayo? Yes, sorry.
No. Well, we would like it Mayo, Myriad, and Alice.
If we can get back, we'll get to the office, but we are not trying to get around any of this. I think that's precisely what we're attempting to do, at least those of us who've worked on it.
In terms of the possibility of patenting human genes, we want to make sure we're not harming your work. Let me put it that narrowly
Exactly.
and
Mr. Lee?
appropriately.
Just to answer Senator Coons, your pressing question directly. Currently, more than half of U.S. patents, I think it's 56% or something like that, and more every year, are being granted to foreign recipients and not U.S. recipients. So if you relax the rules and limits on patents across the board here in the United States, the benefit of that, some of that goes to U.S. companies, it's true, but more than half of the patents are being granted to foreign companies. So you're granting control over those technologies, more than half of them, to foreign countries or companies from foreign countries. So that should be factored in as well.
Is your argument that we should weaken the American patent system so that exclusively they can patent them overseas?
No, what I'm saying is that relaxing Section 101 limits, relaxing patent eligibility limits, and expecting that that is going to boost U.S. national security, I think it's a tenuous relationship between those, because the benefits of the patent system currently, unfortunately, and we should do something about this, are flowing more to foreign patent recipients than to U.S. patent recipients.
Okay.
We've worked together very well since 2019. I think the debate club thing works. I wouldn't recommend every chair doing it. But the fact, again, it is to point out that we're not here to talk past each other and score a big opening statement or a killer answer to a question, folks. We're trying to solve a problem here. And I believe that the problem exists. It may not exist, and it may not feel broken to you, but there are very demonstrable examples of where we're losing the opportunity to innovate. We just want to get that right. That this is the discourse here was great. I like the perspectives of both sides. I would encourage you all to continue to engage, and hopefully we reach a point to where everybody thinks that we got to a good work product. But this is going to conclude our hearing today. Mr. Lee, I would appreciate, for the record, if you would respond to Senator Hawley's question. And I'll take a look at it as well. The record remain open for 1 week for anyone to submit additional materials. I should also say that I'll be submitting my written opening statement for the record as well without objection. Thank you all. This hearing's adjourned.
Thank you.